can be devastating to a family and make to any community, no matter what incentives are offered to try and make the process easier. Perhaps that's why the Navajo and Hopi land dispute has been called the greatest land title problem in the West. And perhaps that is why the relocation program, which was created to solve the problem, was expected to take 5 years and cost $41 million. Well, it continues today, 40 years later, and $568 million after its inception. We're here today because this subcommittee has redoubled its efforts to succeed where so many good people before us have fallen short. In December 2014, at the subcommittee's request, the Inspector General of the Department of Interior published a report concluding that the Office of Navajo and Hopi Indian Relocation cannot complete its work and cease operations in the near future without legislative changes and or an increase in annual appropriations. Inspector General further pointed out that the increasing appropriations in the short term is a more cost-effective strategy than continuing with the status quo. The report recommended that the subcommittee consider alternatives and determine an approach that will best control costs and complete the relocation mission in an acceptable, judicious, and timely manner. In January 2015, members of this subcommittee visited the Hopi tribe and the Navajo Nation to see the challenge firsthand and to hear from those most directly affected about what has gone right and what has gone wrong, and where we should go from here. The message we heard was clear. Don't leave until you finish the job. In December 2015, the subcommittee more than doubled the relocation program's budget to $15 million in FY16 in order to reduce the backlog of 96 certified applicants awaiting relocation and to work through 200 additional known appeals. Just this week, the Office of Inspector General released its second subcommittee commissioned report, which looked into the allegations made by relocated families that homes and infrastructure are incomplete or in need of repair. The law says that the Office of Navajo and Hopi Indian Relocation shall cease to exist when the President determines that its functions have been fully discharged. In consultation with this subcommittee, the agency has set a goal to complete its work so that the next President can be in a position to make such a determination by September 30th, 2018, about 2.5 years from now. The FY17 budget proposes a modest 3% increase to work with the Navajo Nation, the Bureau of Indian Affairs, and the other federal departments and agencies to ensure that this program can be brought to a fair end and to ensure that any responsibilities remaining after the closure will be transferred to the appropriate federal and Navajo entities. Clearly, there's much to be done, and the devil is always in the details. Hopefully today's hearings will flesh out some of those details and begin to put us on a path to completion as quickly as possible, but not a day faster than is needed to ensure that those affected by the program have been treated fairly, honorably, and with dignity. This is not a partisan issue, it's a human issue, it's a nation-to-nation issue, it's an opportunity to make good on a commitment to shake hands and let deep wounds begin to heal. My former boss, the late President Ronald Reagan, once said, "No government ever voluntarily reduces itself in size, so government programs once launched never disappear. Actually, a government bureau is the nearest thing to eternal life we'll ever see on this earth." If he were alive today, he may have to make at least one exception. I'm pleased to join today by my subcommittee colleagues, as well as the senior leadership team of the Office of Navajo and Hopi Indian Relocation, Executive Director Chris Bavasi, Chief Financial Officer Nancy Thomas, Chief Counsel Larry Ruzal. Welcome. It's nice to see you all again. Thank you once again for your hospitality last year during the subcommittee's visit. Before turning to you for your opening statement, allow me to ask my friend and colleague, Subcommittee's ranking member, Betty McCollum, for her opening remarks that she might wish to make.
Thank you very much, Mr. Chair. Good afternoon, Mr. Bavasi, and for those of you who are joining you here today for this hearing. When Congress created the Office of Navajo and Hopi Relocation in 1988, it did not envision that the office would still be operating 28 years later and that families would still be awaiting relocation. America has a responsibility to meet its commitments to the Navajo and Hopi people, and we're here today to better understand the status of the relocation effort and whether or not the office is prepared to start closeout of the relocation process and the office. Throughout its history, as the chairman pointed out, the relocation process has been very controversial, and there have been significant delays. But I think the emotional toll on the families that we met with is one that will be with me forever. The issue that has been going on for too long, and now it's time to just resolve it. In January of last year, when the chairman and I and others traveled to Arizona, as I said, we were able to meet with the families, both Navajo and Hopi tribal members as well as the staff from the Office of Navajo and Hopi Relocation. And we listened carefully as they explained some of the challenges that were still out there that they were facing and some of the opportunities and possibilities they saw in bringing this to closure. In recognition of what we learned on that trip, the committee, as the chairman pointed out, doubled the Office of Navajo and Hopi Relocation to $15 million. This year, the budget request for the office maintains that higher level. So I'm hopeful today that we will learn how that increase has been used to assure that the relocations are done in a more expeditious manner, that they will continue to be done in an expeditious manner, and that the proper mechanisms are in place to address any responsibilities that may exist into the future. Because clearly, Congress owes the Navajo and Hopi people the opportunity to bring to closure this issue so that they can start moving forward on working on their future. But we must do so in a proper fashion. So I look forward to your testimony. Mr. Chairman, I thank you for the time, but I also thank you for the trip that you arranged with the staff to go out there to work on this problem. With that, I yield back.
Thank you. And Mr. Bavasi, you're recognized.
Thank you. Chairman Calvert. Chairman Calvert, Ranking Member McCollum, members of the subcommittee and subcommittee staff. You have our detailed statement, but I would like to just say how pleased I am to have the opportunity to appear before the subcommittee today and discuss the Office of Navajo and Hopi Indian Relocation Fiscal Year 17 budget request with you and answer any questions you may have. Before discussing our 2017 budget request, I would like to express our gratitude to Chairman Calvert and the subcommittee for increasing our fiscal year 16 appropriation so that we could begin to eliminate the backlog of Navajo households who have been certified as eligible for relocation benefits but were awaiting appropriated funds, so that the promise of a new home could become a reality. I also express the gratitude of some 60 Navajo households and families who will have signed contracts this year for a new home, about 44 of whom would otherwise have been required to wait several years more before they could sign the contract for their new home. As set forth in the President's budget, most of the money we are seeking in fiscal year 17 is to provide housing and housing infrastructure for Navajos who have been certified as eligible for relocation homes. So again, I'd like to thank you for allowing us to come before you today.
Thank you. Get right into it. The Department of Interior's Inspector General recommends that Congress legislate a sunset date for the relocation program and provide the requisite level of appropriations to meet the agency's statutory obligations by that date. You testified that the agency is focused on completing its work so that the next president can determine or to make a determination on whether to close at the end of FY 2018. The question is, since current law puts the decision in the president's hands, is there a reason why it still may be necessary for Congress to legislate a sunset date?
Well, I think by doing that, you set a sense of urgency that perhaps is not there today.
Does a determination that the agency's functions have been fully discharged mean that the federal government's work is done?
Not necessarily. It means that the work of the office is done. However, there may be other things that other areas in the federal government might have to take on.
Much of the appeal and relocation process is out of the agency's hands. Can a determination be made that the agency's functions have been fully discharged if a case is pending before the court or not everyone has been relocated?
We think that it can. The those responsibilities can be handled by others.
Okay. We all know that failing to plan is the same as planning to fail. My sense is that you're still very early in the closeout and transition planning process, and that in order to meet your target date, you'll have to pick up that pace considerably and immediately. Is that a fair assessment?
I think it's fair, but I'd also like to remind you that this is not new to us, meaning that this whole notion of transition has been in play for a very long time. We thought actually prior to the Nola Herbert case that we would be going out of business a number of years ago. So we were working a number of years ago now with BIA, with the Navajo Nation, the chapter, to develop a transition plan. It did not occur, as you know, and so this is, again, is not new to us. We have a lot of experience in this, and so we have already started meeting with the stakeholders to reinstitute that transition plan.
Okay. Will you, on that, will you commit to providing the committee with a quarterly status report from this point forward to see where we're at, where we're going?
Sure, absolutely.
The law says that your agency may call upon any other federal agency for assistance, and that any failure to provide reasonable assistance must be reported to Congress. So that would be helpful if going forward we continue to communicate and find out how we're. Our intent is to close this out in FY 2018, so we want to make sure that there's no reason for that not to happen.
So is ours.
Okay, Ms. McCollum, you're recognized.
Thank you, Mr. Chair. And, I concur with the request that the chair is making. I think a quarterly report will be very helpful. I want to, I've got a couple of things, but I want to take up something that happened in my office yesterday. Yesterday, I was sitting down with some tribal leaders from Navajo Nation, and we were discussing the water settlement and all the great potential and everything that they have to move forward on their community development. And I was kind of surprised to hear that as they're moving forward with their business to serve those families, that ONER has been working with them on the role of this business capacity lease. And in your testimony, which is not numbered, so it's the last page that I have, you have a statement in here, how to continue this fine program where you're talking about the livestock and some of that you're working on. When we're gone, we'll present challenges for us, the Navajo Nation, and for the local community. You go on to see the Bureau of Indian Affairs. But you're confident that you can collaboratively come up with a solution. So as I'm asking this question, are you taking on some new responsibilities with the understanding or discussions with other agencies that responsibilities are going to be transferred with them and that they're part of the discussion? Can you explain to me what you're, besides the housing, how you're prepared to close out other things? Because we just don't want the housing closed out. We need to have everything closed and transferred.
Absolutely. The only other things that we are, I think what you're referring to are the new lands.
Yes.
And some of the programs on the new lands, like the demonstration ranch and the range maintenance and management program. And these subjects are not foreign to the Navajo Nation or the chapter or BIA. And so we've been in discussions with all of them about how to transition these programs to them. And we will be coming forward with that transition plan.
Well, Mr. Chair, I think we're going to need to know how much that costs, because that's going to be cost incurred by BIA now. And we've been very successful working together in a nonpartisan fashion to meet some of the needs of the Bureau of Indian Affairs, education, and health we just had in today. But, you know, I don't know how significant the amount is or what the expectation is going to be for BIA and for this committee now to have a new line item, because I don't know if we're going to need if there's going to be authorization authority that's going to be required to transfer those funds or not. So explain this to us, how this is going to work and how you're going to account for the dollars in the transfer.
Okay. There will not all of the things I just mentioned are associated with a cost. For instance, the demonstration ranch is self-supporting, and we believe that has the potential to be a revenue generator for the area. And so that should not have any cost associated with it when it transfers. And we're not certain where that would transfer to, whether it be the Navajo Nation, the chapter, or we've developed a separate corporation out there made up of, they call it the 14 Rs, the 14 range units. And so that's a possibility. The maintenance program and the well maintenance, fencing maintenance program, and the range management program will have a cost associated with it, which I can give you the exact numbers, not today, but I can certainly get for you what it costs on an annual basis. And then the question is whether or not the chapter and/or BIA or the nation, whoever ends up doing those things, wants to continue it at the same level that we do. But I can certainly get you those numbers.
Well,
That would be helpful if you could get that for the record.
Mr. Chairman, I think we need to have those numbers because, and I also think we need to understand if there were leases, contracts, memorandums of understanding, whatever was incurred with your office that are going to be transferring over. And if those are considered legal instruments, what the responsibility, whether or not it changes with the resettlement moving forward, because I think with the best of intentions, as you described to us in the committee, when you thought you had noticed everybody to the very best of your intentions, and I do believe sincerely you took every possibility, you landed up in court, and then you had to renotice folks again for the relocation. So I just think making sure that we head off any potential misunderstandings, any potential, miscommunication, and that we clearly know what these costs are and what responsibilities are being transferred over to other agencies would be very important for this committee to have, because in essence we're closing out the housing relocation, but we're still continuing some of the other issues. I mean, you said that the Navajo Nation might want to just the ranch is self-sufficient and it's done, but we need to know that that's a mutual understanding, and there's been consultation with the Navajo Nation on that, and that it's clearly spelled out.
I'm not sure I could agree with you more on all of those subjects. And that will be part of the transition plan that we will be getting to, hopefully on more than a quarterly basis.
Well, Mr. Chairman, I think it could have been some of the discussion earlier with us on the transfer. Thank you.
Thanks, General. Mr. Cole.
Thank you very much, Mr. Chairman. And again, I want to thank you and the ranking member and your predecessor, Mr. Simpson, for really working hard to try and bring this program to an appropriate and successful conclusion. It's not been an easy task, obviously, and you're to be commended. I want to tell our friends we appreciate your help and your hospitality when we were out there. It was an eye-opening experience, and I felt like we got a lot of candid advice and a lot of history, and was very pleased with the level of cooperation we got. I think I'm going to have a series of questions, but I'm going to posit something. My big fear, and I suspect this committee's big fear, is if we get to the end of 2018 and we've doubled the budget, essentially, and that just means we're going to have another 40 years with a higher budget. That's how I would describe failure. There's some danger of that, given, and I don't point fingers at anybody here, but given the history of the program, there's every reason to believe that could happen. It can't be an in perpetuity housing program. We have housing programs. So if you will, give me an idea of where we are in the process, the number of families that are eligible, if you will, the scale of the task in front of you, and how fast are we proceeding in getting people appropriately taken care of and relocated?
We have, at the moment, 92 families that need relocation benefits. There are, at this moment, about 190 appeals. And in the past, the success ratio for an appeal has been about 1 in 10, about 10%. So we're thinking perhaps another 20 families, perhaps. So we're talking about a little over 100 families that will need benefits. And so we should be we should be done. We'll have 60 this year. We'll have 60 contracts signed this year, and should be able to finish the rest.
That's good. Now, when we were had genuinely pleasure of visiting the area, we visited Navajo Community, East Mill, and Hopi Spider Mound, and obviously in those areas there were houses that had been built that were deficient. So it's one thing to take care of people that have been on a waiting list and moving along there. Tell me about where we're at with folks that were given houses in good faith and those houses weren't appropriately built. Where are we in resolving that? And are we going to have to go back and rebuild? Can things be repaired? Just how big a problem is that for us?
Well, this is not, well, that's a difficult question.
It was meant to be.
Yeah, meaning that I don't know how difficult it's going to be for you. But our program is not a perpetual housing program. Our program was intended to be over much more quickly than it is, and I think we all know that a variety of reasons why it has not. But one is that this is not a forced relocation program, so people frequently take their time to get through it, number one. Number two, and probably more importantly, when this was first discussed in Congress, it was planned to be about 1,000 families. It's turned out to be over 3,800 families that have been certified. So that's one reason it's taken longer than it needs to. But we have the mechanism in place to build the houses and build them quickly as long as we have the appropriations, and thank you for that. And so we should be able to have this done without any problem at all by the time frame we said we'd have it done.
Is there any provision or concern again? We certainly heard complaints about this house wasn't appropriately built, that sort of thing. What are our obligations? Number one, is that true? And then there's a big difference between something that hasn't been cared for appropriately and something that was built defectively. So I know you got to sort of sort through that. But I'm interested in how big a problem that is and how we resolve that portion so that insofar as we can, people that think they were given homes that were poorly built or poorly sited, if there's legitimacy to that complaint, that they're resolved.
Any complaint we get, regardless of how old it is or how old the home is, we will go out and inspect without question. If it is a latent defect, meaning a defect we did not spot when we were building the home, we will fix it immediately. If it's under warranty, we will fix it, and we will fix it immediately. Generally, that's not the case. Generally, for an older home, it's what we refer to as homeowner maintenance. And folks are expected to maintain their homes like anyone else would. And so all the houses that we have built in my tenure there have met all international codes. So there's not been, at least any evidence that I'm aware of faulty construction.
Yeah, and I don't think there has been in terms of during your tenure and the people that were there. There was certainly some concerns that predate you. It's a problem you inherited, so I don't want you to think this was directed at you or any of your current employees. But we did see some instances, and so I'm curious how those cases get resolved. Is there an appeal process for that, so that there's some adjudication of this, if you will?
Well, when they come to us, and that's why I was saying, and I was not trying to be flip, that I'm not sure what problem you may have, because when they come to us, you've come to us with a problem, we immediately inspect it.
Okay.
If we are responsible, we will fix it immediately. If not, then we will tell you exactly what has caused the problem, what you need to do to fix the problem, and that's the end of our responsibility.
Okay. There's also, as you know, and you've been generous with your time, I'll finish with this question. An appeals process here, which, as I understand it, will last beyond your tenure, assuming we reach the guidelines or the target dates that we're all collectively shooting for here. Tell me how that works, how anything that there's a legitimate appeal gets resolved once the office itself goes out of existence, and who would be responsible for, if there were a judgment rendered, paying that judgment. I think that's sort of what Ms. McCollum was one of her concerns too. We don't want to just end the office. We do want to discharge the function fairly and appropriately. We want to make sure if there is some aftermath, if you will, as we wind things up, that gets taken care of, and we do indeed end the effort.
Our plan is to have all of the homes built by the time we are out of business, to have everyone have gone through the appeals process by the time we are finished. However, you are correct. There will be a 6-year time that they can appeal to the federal courts that determination. And as we've discussed in the past, that's going to have to be some kind of responsibility of, and we haven't quite figured that one out yet, whether it's going to be Justice Department, Department of Interior. I'm not sure how that's going to work. And we've also talked about the possibility of having some kind of a trust fund set up to accommodate if there were to be.
Well, just out of curiosity, and I direct this much to the staff or to my colleagues, is this something like the judgment fund or something would be in a position to cover? Because that's a very substantial fund, and it's a pretty well-established method as to how we handle those. And what you don't want to leave is people hanging out there or forcing BIA or somebody else to pick up some obligation that they had not anticipated that, you know, diverts funds from someplace else.
Yeah, gentlemen would yield. I'm hopeful that as we go through this process over the next 2.5 years, the legitimate questions that are being asked are addressed early, get that out there. And I'm sure even after this office closes that we probably will have to move some money over to the BIA to carry on some of these legacy responsibilities. We were out there at Spider Mound, and it seemed to me, just looking at it from my old job as a builder, that there were some subsidence issues around there, and that there may be some legitimate concern over that, over and above, immediate construction remedies that you do as a normal course of business. But that may or may not be the case. I'm not sure. We'll leave that to the experts to decide.
East Mill, sir.
What's that?
East Mill, not Spider.
Excuse me, East Mill. And I get these places all mixed up. So I think we need to make sure we have a budget when we conclude this, where we don't delay concluding your job, but move that responsibility to someone else, where we can make sure that happens. So we need to work with you to make sure we have sufficient funds to move over to the BIA, to make sure whether the judgment fund is involved and all the rest of it, so we can answer those questions when we move along.
Well, I yield back my time. Thank you, Mr. Chairman.
Mr. Chair, just so there's, if things go to court, and I'm not an attorney, but it's been my experience here in Congress, if things are clearly settled in a court, then it goes to the judgment fund. And that's why I think we need to know what all these legal documents are going to be looking like and what they are. And I think we need to have the administration's attorneys look at it, the congressional staff who overview and look at that, so we know exactly what we're getting into. And I concur with both gentlemen that, some of the things that we saw appear to be the fault of contractors. And, then you get into whole warranties. I warranty this or I warranty that, or it's an act of God. But one of the things that I found really was we were in this area where all the foundations were cracking because there was a helium deposit underneath that. What's been the resolution on that? People were asking that to be checked out. What was the final resolution on that area?
Well, that's East Mill. And I don't believe that it's a helium deposit issue, but I'm not an expert on that. But it is a expansive soil issue. And what we have done there is we have gone into any house that shows any problems. We've gone in and fixed the home or replaced it. We have replaced 4 homes, and we will, as they come along, if there were to be another home that needed to be replaced, we would certainly do that.
Well,
Generally, you're still building homes in that
No,
area?
no,
Okay.
we are not.
Okay, excuse me. Sorry.
yeah, and thank you for clarifying that, because that was going to be what I asked. So we're done building homes there, but anytime you have a soil conditions can, change at the bat of an eyelash. I mean, if you already know you have a poor soil condition there. So that goes back to, you said you had people inspecting and everything was state of the art. Who is overseeing the inspection process, the soil siting process, all those kinds of things? What code are you using? Are you using federal code, state code? What kind of engineering
Use
system?
international codes. And we do all of the inspection. And we bring in outside contractors if we need to have, in the case of East Mill, we had some helical piers put in. And so we had outside contractors do that.
Well, I just hope that we're not being too naive in who we're having to do the contracting. I know it goes out to bidding, and bidding's important and everything like that. All of us want to respect the taxpayers' dollars, but some of the things that we've seen in schools and elsewhere have not given us, and this is not to you personally, has not given us great confidence that inspection procedures have been carried out to their full benefit. So any help that you might need in order, sometimes the lowest bid's the best or whatever, but we really want to make sure that the inspection process is done properly, because soil siting at the school that we saw, which has nothing to do with the project that we're talking about today, some of the contract work that we saw at that school, I mean, it was just, when I can see things, and Mr. Calvert, who has a lot more experience than Mr. Cole on this one, I can see things, they're even seeing more things that were avoidable, that the taxpayers are not having to go back and do again. So if there's any help you need in making sure that if we have to double inspect or something like that, we need to get this right. And I know that's what you want to do, and I have every confidence you'll do that. But if you need any further help with us on that because you feel your hands are tied in some way, please don't hesitate to ask us for our help.
Thank you, I appreciate that.
Just a couple other questions on this relocation process. Does your agency have the legal authority to choose an eligible recipient home site for them?
We do.
Okay. How many times has your agency exercised that authority?
None that I'm aware of.
With your increased workload and target closeout date, does your agency intend to exercise that authority, and if necessary, to meet your deadlines? If not, what's your alternatives?
Well, I suppose we will if we need to. We're hoping that's not the case. Of all of the folks who are certified eligible at the moment, as I mentioned earlier, there's only 11 that have shown that have not been forthcoming and worked cooperatively with us. And they have all been notified that they needed to respond to us more quickly, or we would administratively close the case.
Yeah. This is important because, we don't want to come back here in a year or 2 years, and find out that, there's a person that stops this whole process. That's what's happened before. So that's something that's important because, again, I want to see this close out at the end of 2018. So any other questions? Mr. Joyce?
No, sir.
Oh, okay. Betty? Okay, fine. Well, appreciate your coming out from Arizona. We appreciate your being here. Thank you so much. And this hearing's adjourned.
Thank you for your help.
Okay, sure.